Hey folks, Toby Mathis here and joined by John Anderson. Hey John,
Hey, how are you?
I'm doing well. And hey, we're going to dive right into the winners and losers under the Trump administration. Trump won, he's the president nominee, and looks like the Senate is going to be Republican and the Congress is going to be Republican. And that just puts us in a scenario for that estate planners have been dealing with kind of being in limbo and the Tax Cut and Jobs Act expiring. There was a bunch of provisions that are causing a big fervor in our world, and I want to talk about those winners and losers, and also the big mistakes that we've seen over the last couple of years as people overreact to what was coming down the pike in the form of the Tax Cut and Jobs Act expiration. So let's dive right on in. So John's an expert tax attorney, estate planning attorney. Deals with this stuff on a daily basis, and I invited him along so that we could dive into this fun realm. And let's just go right off the bat, John. What are the big changes that everybody was trying to do planning around that they were worried about in 2025, 2026?
Yeah, so when the Trump tax cuts were first started or signed into uh, being, there was an automatic sunset at the end of 2025. So the exemption amount was doubled under those Trump tax cuts, but it was going to get cut in half after 2025. So right now it's about 14 million, a little bit less than 14 million for an individual, and that would have been cut in half to about 7 million after 2025.
And so in English, that just means that there's this exemption amount that you can give away or that you can transfer upon your death. There's unlimited amount you can give your spouse, but let's say you pass away and give it to your kids. You have this big tax because it's like goes up to what 40% on the federal side and then up to 16% on the state side, where you can get hit with this tax that really, I mean, pretty devastating to an estate. And planners were worried about people that were in that realm of, hey, you're going to be over if it's a single person, over that $7 million route, you could get hit with this thing. So we better do something now since we have twice the exemption to play with. Is that accurate?
Correct. Yeah, you could use up the exemption either while you're alive through gifts, or you use it after you die in the form of an estate transferring assets. So they were basically saying, let's use it now while we know we have the higher exemption through gifting before it gets sunset and gets cut in half.
And so, how are they using it, John? Like, what were the big tools that they were using?
The number one tool that I saw being marketed were SLATs, Spousal Lifetime Access Trusts, where you would create an irrevocable trust for your spouse as the beneficiary, and then you would gift assets into that trust. Now, your spouse can get income and use or limited use of the assets within that trust during their lifetime. And then when they pass away, it's not subject to the estate tax because you gave it away and your spouse only has limited access to those assets.
There's two things that I saw. Number one, there's a huge drawback on that, right? Like you're because it's not subject to the estate tax, you lose something, right?
Yeah, so you lose out on the step up in basis, meaning so if your tax basis is in an asset, it's usually what you pay for it. And then when you sell the asset, the difference between what you bought it for and what you sell it for is your gains, your income that you have to pay taxes on. Well, if you're subject to the estate tax, the step up in basis resets to the fair market value. So if the asset was worth $200,000 now and you only bought it for 100,000, your basis when you die is now 200,000. But if it's not subject to the estate tax, you don't get that step up in
And
basis.
it doesn't mean that you're getting hit by the estate tax. It just means it's part of your estate. So if you have a $5 million estate and you just let it run its course and you pass away and you're in a state that doesn't have an estate tax and the federal estate tax is above that amount, you get a step up in basis on the entire 5 million and you have no estate tax. What they were doing is focusing on people that they thought, oh, you we may be subject to this tax if it expires in 2026. So let's give it away now to a SLAT And unbeknownst to a lot of people, they just gave away the step up in basis. And I don't think that was being explained to people that, oh, by the way, now you're going to pay tax on the sale of that. Whereas if you had just passed with it and under the provisions as they are right now, you wouldn't have paid any tax. You would have avoided tax entirely. Now we're guaranteeing that you're going to have a tax. It's just less than the top estate tax. Is that fair?
Correct. Yeah. So you get a step up in basis because there's always an estate tax owed, no matter what your value is. It's just the government provides a credit that
Yeah.
pays that tax for you up to about the 14 million mark.
Yeah, this
Um,
2025 is what, 13.99 million. I think it's
yeah.
13.61 in 2024.
Right.
I think that's right. Yeah, for an individual, then double it up if it's married. Oof,
Correct. Yeah.
that's a big
So
amount.
the the other thing that you're missing out on, you're not just a lot of people think, well, I'll just hold on to the assets and I don't have to pay the tax. You got to realize your basis is also where you're determining depreciation from.
Hmm.
So if you had gifted assets and you've depreciated it all out, you just lost out on or at least your heirs or your spouse lost out on a whole bunch of depreciation they could have done all over again because that
Let me
basis
use
would have reset.
I want to use an example because we had this same scenario when we had the estate tax went away for 1 year, and then it was coming back. It was going to be $1 million, and everybody's freaking out. And I recall this because I had a client come in, and she had and three siblings. Dad had transferred a building into a limited partnership and gifted the limited partnership interest to all the kids under the auspices of an accountant, and it was like a couple $1 million. But because he did that, the basis in that building, I think the dad had owned it for like 30, 40 years, was next to nothing. There was just a little bit of land value. So these kids sold it after dad passed, and they didn't think they owed any tax. And unfortunately, the entire transaction was subject to it wasn't a small capital gains hit at the time. I think it was around 28% plus the state. So they were paying in, over, I think it was about $700,000-800,000 in taxes that would have been completely avoided had the accountant done nothing, right? But because they got cute, they ended up triggering a tax that would have, again, you cost this family hundreds of thousands of dollars because, oh, this could happen, and we're seeing it again. And then even worse, you're seeing it with people that don't know what they're doing, right? So I'm sure you've seen this, but there's reciprocal trust doctrine. You have these people setting up SLATs for both spouses, right? And they're not even going to be effective.
Yeah, so I just the marketing around this whole sunset has been pretty crazy, and there's been a lot of people jumping on board, right? Problem is, a lot of these people that were promoting these things didn't really understand the case law and everything that goes along with a SLAT. And they were creating, a SLAT for the husband and a SLAT for the wife, and then they were gifting assets between the two of them. That's a clear case of the reciprocal trust doctrine, and the courts have clearly said, no, this doesn't avoid estate taxes. But you still used up your exemption because you file, when you create the SLAT, you file a 709 with
Mm-hmm.
the IRS that says,
Which
I'm
is a
using
gift
up my
tax return.
exemption. Yeah, it's a gift
Just want to make sure
tax.
people understand that's a
Yeah.
gift tax return. You could die and use your exemption, or you could give the asset during your lifetime and use the exemption. And what you're saying is, I'm using my higher exemption now. And you're saying to the IRS, I gifted this, which kind of crazy when you think about it. I gifted it to this trust, and I used up my exemption for whatever. Like it could go up, but I've used this much of my lifetime exemption. Oof.
Right. So that's already filed with the IRS. So as far as the IRS is concerned, you used it. But then they can come back and say, well, you
We're
didn't
not.
do this properly, so we're not going to honor the estate tax, or you're
Yeah.
still subject to the estate tax. Yeah, so it can create some pretty big messes if
Again,
this
it
was
comes
something you
back to
did.
this thing. It comes back to this. Sit on your flipping hands sometimes. Like we don't
Yeah.
know what the future is, and these guys are getting so far ahead of it. I was reading a estate planning article that was written after the election, and they were like, "Oh, the last 2 years have been so busy for us, and now we're being thrown this." And it's like, why were the last 2 years so busy for you? Like, you were anticipating something happen in 2026, so you were creating work based off of, in many cases, sets of facts that were hypothetical. And the clients are now worse off, especially for these folks that didn't know what they were doing. And like you said, did the reciprocal trust doctrine, which means it's not effective for the, for its purpose. It's going to be included back in the estate, and you already used your gift, and you lost your step up.
Yeah.
Like, what are the downsides of that? Like, let me dissect that for a second. Did I say that right? Is that actually what's going to happen to them?
Yeah, you have a higher tax bill than if you had just done nothing.
Yep.
And you paid whatever the lawyers' legal fees or whatever they were that didn't actually help you at all, just made things worse.
Oh my. So let's turn this into hope. What would you be doing now? Because we don't know what the administration's going to do. Like, we have an idea of what it said on the campaign trail, which was to extend the Tax Cut and Jobs Act. But we don't know. They wanted to get rid of the estate tax in its entirety. 2017, they couldn't. They had to. They couldn't get that through because they didn't have 60 votes in the Senate, so they had to use another process. But that's still on the table. Just extending it's on the table. What's somebody to do, because we don't know yet?
So I would do, if you're over the current amount, then I would use strategies that would be able to remove some assets from your estate, not all of them, but some of them up to about the exemption amount, and still preserve the exemption. So that
So
about
right
that
now
14
we're
million.
at 27.22 for a married couple, 27 million and some
Yeah.
change. Next year it'll be closer to 28 million.
Yeah.
If you're over that amount, or cut those amounts in half, it's 13.6 million. For an individual. It'll be 13.99 million next year. But if you're over that amount, then do what?
So you can create irrevocable trusts that don't use up your exemption. You're not making gifts. What you're doing is you are transferring the asset into the irrevocable trust, but you're getting something back in return. So there's two different types that are commonly referred to. One is a GRAT, or a grantor retained annuity trust, and the other one is an IDGT, an IDGT, which is an intentionally defective grantor trust. They're pretty similar. The difference is, with a GRAT, when you give the asset to the trust, you get an annuity in return. So the trust is paying you back a set amount every year. And because you're getting something in return, this isn't a gift, so you don't use up your exemption. But because the asset is in an irrevocable trust that you're not the beneficiary of, it's not yours for estate tax purposes. An IDGT is similar, but instead of getting an annuity in return, you're selling the asset to the trust and you're getting a note in return. And
Mm-hmm.
you're getting paid back based off of that note.
And
And
so you
so,
have a note that's potentially part of your estate, and then you put in I think you have to have consideration with a
yeah.
self-canceling installment note to keep it out of your estate ultimately. But, again, work with a skilled estate planner to put this in place. But it's a fancy way of saying, hey, we're getting it out of our estate. There's a famous case, right, that did this.
So with the GRATs, there's a couple of examples out there. So for example, Mark Zuckerberg put his shares in Facebook into a GRAT before it went through the IPO. So
It's worth very, very little.
yeah, it wasn't worth nearly as much. But all that appreciation that happened is now within the GRAT, which is outside of his estate. The Walton family also, there's a case that went to the Supreme Court dealing with them and the GRAT, where they put assets or shares into the trust. The annuity would pay back the full value back to them over a period of years. So there was no gift exchange there,
Mm-hmm.
no gift value, and the Supreme Court upheld it. and said, yeah, this is totally legal.
In what you're trying to do is get the growth off of that out of your estate so that you're not, again, if I have an estate, if I'm worth 14 million and I sell it to an idiot, an intentionally defective grantor trust, and I take back a payment stream, fantastic. I'm never going to run out of money. But if that 14 million, like I put it all in Bitcoin and now it's worth 50 million, it's not in my estate. It's not going to get hit with that 40%. Is that fair to say?
Correct. Yeah, you want to look at assets that have a high potential for appreciation, and that sell, it's not a taxable sell. When we say it's an intentionally defective grantor trust, as far as income taxes go, the IRS treats it as if you took it from one pocket and stuck it in your other pocket.
That's why it's called intentionally defective grantor. For tax purposes, we're ignoring it. So you
Right.
sold it to yourself, which means you didn't do anything. But for estate tax purposes, it's out of your estate. Is that
Correct, because in the tax code you have the income tax section and you have the estate tax section, and the definitions do not match in those two laws or sections of the law. So what we're doing is we're playing with, okay, under this section, this wasn't a transfer, it's not a sell for income, but under the estate tax section, this was a transfer, and it's not part of your estate anymore. So because there's a difference between how they define the terms in those two sections of the law, we can take advantage of that and get the asset out of your estate, but not have to realize the actual gains.
All right. I want to ask people out there, if they're listening this far, that means that they have an interest in this. What do you think of the estate tax? Put it in the comments below, whether you think it's fair, whether you think you should get rid of it, whether you've heard anything else, like maybe your financial planner pitched you some other idea. Throw it down in the comments. We love to respond to stuff like that, and people love to see what everybody's hearing and being told out there. And then I want to throw one thing out there. There's another solution which just came up today. There was an article written about Buffett and giving most of his estate to 4 foundations. I mean, I think these are family foundations. He's keeping control of them, and he's like, I don't want to create a dynasty while he's creating a dynasty, right? And there's always charitable giving. Like if you really get down to it, you can create. What would you do? What would you advise somebody if they wanted to get something out of their estate? Maybe get a tax deduction, not just avoid tax, but get some tax relief. What would you have them do?
Yeah, there's a couple of different ways of doing charitable giving. You can create your own foundation, right? And that's what Buffett basically did, or had his kids create foundations and contributed to them. And so anything that's in that foundation, it's not part of your estate.
Mm-hmm.
You get that tax deduction during your lifetime. If you don't necessarily want to create or go through the process of creating your own foundation, you can do charitable trusts, where you can retain a certain amount of income during your lifetime, get a deduction while you're alive, and then whatever's remained after your life goes to a charity. Now, a lot of times I will caution people, charitable remainder trusts, the way they're marketed by most people, is as a tax savings. It is a really bad tax vehicle.
Yeah.
It is good for charitable giving, right? If that's your intent, then yes, it can be useful. If your intent is just to reduce the taxes you're paying, it is an awful vehicle for doing that. Don't do it.
The tax deduction is based on the future value of that
Right.
interest. So it's about 10% usually. So if you give $1 million
10% is pretty
to a
common.
short remainder trust, you might get $100,000 deduction.
Yeah, 10 to 20% is pretty typical. You're
Yeah,
not
it's
you're
not.
not going to get much.
And I'm sure there's some planner out there going, "No, I always get 30." It's a calculation. Don't
Yeah.
get crazy, right?
Yeah.
It's
But
the numbers.
yeah, if your intent is to, or I mean, the other option, if you don't necessarily need income from the assets, then you can do like a directed fund,
Mm-hmm.
where you're giving today to a charitable organization, but then you can direct where that's going to other charities later on.
You
Um,
could, and I would just set up a family foundation under those circumstances and say,
yeah,
"Here's who I want to benefit." Right? There's so many ways to get there. I like the to have control. So I'm always going to tell people, if they've been on my channel at all, they know that I like setting up charities that have the family support, so to speak, right? You can do foundations; those are great, but and they give to other charities. But I really love it when your charity's at home. It's something you want to do. You get your family behind, and you get a nice tax deduction for funding that puppy, but you're giving your family a legacy that they can that then they can work for. And yeah, your assets not going to anybody in particular. It's great if you don't want your estate going to ex-spouses or litigants or creditors or
The
angry,
government.
yeah, the government. But it's really cool. It's a great vehicle, and you see Buffett doing it. You see a lot of other folks doing it, where you can give your estate to a charity and avoid the estate tax in its entirety. Have your family continue to work for that charity, and you can even have founders shares and veto rights and things like that are built in, so that they maintain a certain degree of control, but they're doing it for a charitable purpose, and they only get paid if they work, which is an interesting concept that seems foreign to some folks, but a lot of people embrace. Any other strategies that you think of that you want to hit on, or did we just nail them?
Yeah, I think those are the three main ones, either preserving it with a IDGIT or a GRAT or through charitable giving, so that we still have that exemption available so that we can at least get a step up in basis on some of the assets, right? And save on those taxes even more than maybe someone who jumped the gun and went ahead and did this already.
All right, send this video to your over planning friend who's doing way too much. Tell them to slow the roll and sometimes use a little more thought before they pull the trigger on things. There's estate planners out there using the expiration of the Tax Cut and Jobs Act as a marketing ploy to get people to do things that may not be in their best interest. They may be well intentioned, but quite often they just know enough to be dangerous, and they're using it to generate some income for their firm as opposed to what's in the best interest of the client. I know some of you guys are going to hate on me for that. Great. Put your comments in below about why you think that's a wrong statement. I'd love to hear it because what I've seen is a lot of over planning. Share this with folks that you think could use it. Like and subscribe. John, if somebody wants to get a hold of you, I'll put a link in there for a strategy session or something, but also you could just write in the comments, hey, I'd like to talk to John Anderson, and we'll see it and we'll make sure that we reach out and get you a link so that they can ring your bell and your team and your staff. And I just want to say thank you for coming in and joining us.
Well, thanks for having me.